Welcome to the law firm of Kitrick, Lewis & Harris. We appreciate you being here with us today because I know you have a lot of questions and concerns as you go through a very difficult time. Before I talk about some of the common questions and concerns that may be on your mind, it's important for you to know that we are leaders in the industry, that we have been recognized by our peers as the best of the best, and our track record is outstanding. We believe an informed client is the best client. And to that extent, we're going to make sure you're updated regularly. We're going to talk consistently to the insurance companies and their attorneys. You're going to have the full thrust of our law firm fighting to protect you and only you. We are here to protect and fight for you. You're going to have a lot of questions and concerns, and I'd like to go over those with you today. How long will it all take? Once you reach the point where you're either perfect or as good as you're going to get, then we here at the law firm of Kitrick, Lewis & Harris attempt to get the case settled. If the case doesn't settle at a number that you feel is fair and reasonable, then we file suit. And that takes us on a different path. Typically, if we have to file suit, it takes approximately a year to 2 years to get to trial. If we can get the case settled before we file suit, it can take 6 to 9 months, maybe a year, again, depending on how well you recover. What's important to remember is consistency of care. Treat consistently with your doctor. Do what your doctors tell you to do. Keep a good diary of what happens to you day by day. Tell your doctor in writing what hurts you. Start from the head and work your way down. That way you won't forget when you're meeting with the doctor. All these things together help prove your case. Again, the burden is on us to prove that.
Proving your case depends on us having the right evidence. That evidence includes medical records, medical bills, and wage loss documents. You can help us obtain this evidence. Whenever you receive a bill in the mail, please send that medical bill to us. We will order your medical bills and all your medical records as well, but we ask that you cooperate by giving us those bills. We'll also contact your employer to get information on your past employment practices. Your employer should be able to provide us with employment records to prove your wage loss. Of course, when talking about your past employment and your past medical history, we ask that you be forthcoming and share with us all your prior medical history. This becomes crucial in litigation or in your case because your past medical history becomes relevant. And in order to best protect you, we need to know everything about your medical history.
You have several options to get your medical bills paid while you continue to treat and before we settle your case. Keep in mind that the other driver or the at-fault party is not responsible to pay your bills until the time of settlement. That's because our office wants to present a complete medical picture both of your injuries and your medical bills all at the same time. In the meantime, you can use your health insurance to treat as normal, to go to the doctor, to go to physical therapy, etc. You may also be able to use your own car insurance depending on the type of coverages that you may have purchased. One type of coverage with your own car insurance is called medical payments coverage. It functions just like health insurance. We can take a look at your insurance policy and let you know whether you've purchased that coverage and in what amount. Keep in mind that whether health insurance or medical payments with your own car insurance pays for your medical bills, they have a right to be paid back out of your total settlement. That's called their right of subrogation, if you've heard that word. That means that our office, has to reimburse your health insurance or your car insurance for the money that they've forwarded or paid for the bills up to that point. In this way, it is actually the at-fault party that is paying your medical bills, albeit in a roundabout way through our office.
What are you entitled to in your case? There are 3 basic ingredients. Number 1, your medical bills. We must keep track of all your medical bills, regardless of who has paid them. That also includes miscellaneous damages, trips back and forth to the doctor and hospital. Keep track of those costs. Prescription costs. Miscellaneous costs also include things like housekeeping, yard duties, and such. The second ingredient is your lost wages. If you miss time from work or miss income, you're entitled to every penny of that. We want to make sure we document that and obtain that for you. The third ingredient is pain and suffering. What is pain and suffering? Pain means the pain itself, the physical injury to you. Suffering is the mental anguish that this has caused you. When we add those ingredients together, that's what you're entitled to in your case. Beyond that, there's no other magic formula, because there's no one like you. You're unique. You're different. Therefore, there are no other cases just like yours. Remember, we must prove everything in the case, and the defendant doesn't have to prove a thing. As a result, we must prove things with what's called reasonable certainty. In other words, we're not allowed to speculate and say, well, this could have happened, or that might have happened, or maybe this happened. The would-haves, the should-haves, the could-haves in life that we sometimes talk about are not allowed in the law. So, for example, if you need future surgery, we must have the doctor say you're going to need it, not maybe you'll need it. When you settle your case, when we settle it at your direction, it is over forever. So we must make sure that we do it at the proper time for you. Remember, as we walk side by side with you down the legal path, we want you to focus on your health while we focus on prosecuting your case to the fullest extent of the law.